Thank you so much for being here. My name is Malkie Scher. I work at the Moskowitz Legal Group. We're an elder law and estate planning firm, and I head the special needs planning division. I do special needs planning and guardianship. But the topic of today's lecture is going to be special needs planning. So first, let's talk through the topics that we're going to discuss today. What is estate planning? Why it is essential. We're going to talk about the basics, wills, and trusts. We'll go through what that means, advanced directives, and then hopefully I'm going to be able to bring everything together for you, and hopefully it won't be too confusing, and I'll make it clear for you and hone it down on what you could do now to protect your family and make sure that your estate plan is set. So what is estate planning? Estate planning is deciding in advance what will happen to your money, to your property, and your belongings after you pass away. I thought that the easiest way to do this was to begin by looking at a real world scenario. Look at a scenario that would be able to highlight the importance of estate planning and be able to make this relevant for all of you. And I'll try to keep referring back to this scenario throughout the seminar so that you could keep seeing how this looks in real life. So let's take a married couple. Let's put them in their 40s. They have 4 children, 3 of who are minors. They're under 18 years old, and they have 1 adult child who has special needs, and they receive government benefits like Medicaid and Social Security. Our question is, what happens if one or both of the parents pass away without proper estate planning? I'm just going to highlight some of the potential problems. We are not going to go through them right now. I just want your brain to start working and start thinking about some problems that would occur with this kind of scenario. So there would definitely be asset distribution problems, meaning, who's going to get what money at what percentage would be big confusion in this scenario. There would likely be guardianship and custody issues. We'll talk about, the risk that this poses to your child who has special needs and the risk that this poses to your minor children. And honestly, family conflict. Without clear instructions of how your estate should be divided, the family members may dispute. They may dispute who should manage your money and your estate, who should care for your children. This could lead to costly and unnecessary legal battles during an already difficult time. Now let's talk about a will. I'm sure everyone here has heard that word, right? A will. People say, make a will, make a will. You should definitely make a will. But I'm sure people have heard that word kind of thrown around. But I don't know if everyone really knows what it means. So I think it's good to kind of just start with this definition. What is a will? The formal term for a will is a last will and testament. And what it is a legal document that specifies how a person wants their money, their assets to be distributed after their passing. It also allows that person to appoint someone to carry out their wishes and manage their estate. That person is called an executor. The will also lets you name guardians for your minor children and dependents. And the will is only effective after the testator, meaning the person who drafted the will, after that person passes away. So if you make a will, you're leaving instructions, you're telling people, this is exactly what I want to happen after I pass away. There are instructions. That's how I like to think about it. So why you need a will? We keep talking about a will. It's a great thing to have. It's important to have. I really want you to understand why you need it. And there are many reasons why you would need a will, but I'm going to highlight, 3 sections of reasons that come up a lot for our office, and I think which will be relevant for you. So the first would be for guardianship for your minor children. So please note, that I also do a different type of guardianship. This is guardianship for an individual with special needs, an adult child with special needs. It's a separate court process, a legal proceeding that is completely separate from this. So erase that definition of guardianship from your minds for just a moment so we could talk about here. This is much simpler. This is just talking about guardianship for your minor children, and you can actually designate this in your will. You can write in your will, I want such and such to be the guardians of my minor children. Next, appoint an executor. Your will names an executor, which is a person who's responsible for ensuring that your estate is properly managed according to your wishes. And the most important reason, literally just if you don't listen to anything I say today, listen to this next bullet point. The most important reason why you create a will is to specify how you want your property, savings, and belonging to be divided among your children, and most importantly, instruct on how you want to account for your child with special needs. If you don't account for it, the law will. So now, what happens if somebody passes away without a will? So in New York State, what happens is something called intestate succession, which basically means that New York has laws about how your money should be distributed after your passing. And honestly, the way that those laws are written is not beneficial for a lot of people because the law doesn't take into account your scenario, your wishes, how old your children are, what your children's needs are. It's just the law, and it works a very specific way, and it must be followed in that way. So if you don't have a will to bypass how those laws are written, your assets are not going to be distributed correctly, and it could cause major complications. So just to give you with the example that we discussed with our married couple, 4 children, 3 minors, 1 child who's on government benefits, that money would get divided between the surviving spouse and all of the children. Now, just think about that for a second. Somebody passes away, they leave behind their whole family. You don't need your money getting distributed between all of your kids and all the complications which will arise, which I'll discuss shortly. You probably want it to be that your surviving spouse gets all the money so they can freely care for all the children without having to worry about how to access the money. So just to explain that in more depth, because these topics can be complex to understand, but just to conceptualize it for a second. If you're married and all of your children are with each other, that you want your surviving spouse to have as little barriers as possible to be able to access these funds and pay for crucial things, to keep paying for the mortgage, to pay for food bills, to pay for medical bills, to pay for whatever it is. You don't want your 5-year-olds coming into a certain portion of your estate. So now, most people that are here specifically got caught by the title, which is this is really about specifically special needs planning. Just obviously we have to talk about some basics of estate planning too. So let's touch on that now, and we'll go more in detail. But what problems will this arise? What problems will occur for your child who has special needs? If your child with special needs inherits money directly, they could lose eligibility for vital benefits like Medicaid and Social Security. I don't know if everyone's really conceptualizing this, because I think that if everyone did, everyone would stop what they're doing and at least make a basic will. Because if your child who is on government benefits comes into a certain amount of money, they're going to be kicked off of their benefits. And we'll talk about ways to get around this. We'll talk about a special needs trust, and we'll try to go through the topics in a slower way so everyone can understand. And now we're just going to touch upon slightly what kind of problems arise for your minor children. Without a will, if both parents pass away, like we discussed before, the court is going to decide the guardians of your minor children. They're going to decide who should take care of your children. This process could be lengthy. It could cause disputes among family members. Most parents want to be able to pick who the guardians will be for their own children. If you don't write it down in your will, the court is not going to follow it and they're not going to know. So simply put, that's a big problem that could happen for your minor children. So just in your will, specify, after both of us have passed away, we want such and such to be the guardians for our minor children. Another big problem that happens for minor children is that, and I don't know that people always realize this, minors are not actually allowed to inherit directly. They're not allowed to come into money directly and that money just be given to them. So instead, their share gets put into something called a guardianship account. Now, a guardianship account could be expensive to set up, time-consuming, and requires court approval for each withdrawal. That means the court has to say it's okay each time you want to take money out of the guardianship account to use for your children. A much simpler way would to be make sure that your minor children don't inherit directly. If you create a will correctly, you can make sure that happens. We're going to take questions at the end. I'm sorry that I didn't specify that. Please write down your questions. I want to take questions at the end. We're going to leave about like 15 minutes or so to do so. So write down your questions. Something to consider, which comes up, is blended families or possibly estranged relationships. If you have children from different marriages, or you have some family members that you're estranged from, the laws in New York could be very unfavorable for you, and that could lead to significant complications. So specifically in those scenarios, you want to have a will because you want to make sure that your estate is distributed exactly the way that you wish, not the way that the state says that you have to distribute it. Okay, we're going to talk about trusts a little bit. And I hope everybody is still with me, and I hope we tie it together at the end in a way that's easy to understand. But what is a trust? And when are they necessary? A trust is a legal entity that's created so that there's one person managing money for another person. The way that it gets created is first there's someone called a grantor. They're the one that creates the fund, the trust. They're the one that puts the money into it. The next person is called a trustee. A trustee is the person who manages it, and they control how the money is being spent. The last person is a beneficiary. This is the person who's actually benefiting from the trust. This is the person who the money is being spent on. And the whole trust was created for the beneficiary. Okay, so now we're going to discuss some common types of trusts. There are many other types of trusts. Trusts could be unique. You could tailor them. You could make them the way that you wish and the way that works for your family. Speak to, a good lawyer who's well-versed in this topic to be able to best guide you here. The point of this seminar is not so that you know everything that needs to be done. The point of this seminar is simply that you know that things need to get done and you know when it's time to go to the lawyer and start discussing your problems, but you don't have to have it all figured out before you step into a lawyer's office. So I just want you to be familiar with some of the types that come up a lot. The first type, a special needs trust. I get calls about this daily at my office, and I think it's good for everyone here to know what a special needs trust is. A special needs trust is a legal tool designed to protect individuals with disabilities, particularly those receiving government benefits like Medicaid, like Social Security, like food stamps, from losing these benefits if they acquire too much money in their name. It's essential to understand in New York how to manage your child's finances if they're relying on such benefits, as even a small amount of money in their name could disqualify them from vital services. So I have people calling my office saying, do I really need a will? Do I really have to start thinking about a trust? I don't have so much money. But if you think about it, if your child who has special needs even ends up with a few $1,000s, depending on what kind of benefits they're on, this could kick them off their benefits. and that's a really big deal. So why are special needs trusts created? Follow me for a second. So by placing money into a special needs trust rather than directly in your child's name, you ensure that they don't lose their benefits. It's like a loophole. You're really saying, I want to give all this money to Jimmy, but you can't give this money to Jimmy. So you give it to Jimmy's trust, which is, like we defined a trust before, that will only be used for Jimmy's benefit. So never put the money in Jimmy's name directly, but that doesn't mean you can't leave money for him. It just means that you can't leave money for him directly. So what could the funds be used for in the special needs trust? They really have broad rules of how the special needs trust could be used, but they could pay for the good things in life, things that maybe they're not able to get from their government benefits. So they could pay for extras, they could pay for vacations, they could pay for entertainments, they can pay for medical expenses that are not covered by the government programs directly. So now back to our estate planning and back to creating a will. How could you leave money for your child who has special needs in your will? You could do it by doing it in conjunction with the special needs trust. So if you're planning to leave money to your child with special needs in your will, you could set up something called a third-party special needs trust. The key here is that the funds never go directly to your child's name. And this allows you to leave money for your child's care without risking them losing their benefits. Now, something that comes up is what happens if your child already has too much money in their name? So let's say like your child wins a lawsuit settlement, or let's say somebody passed away without a will and their child already came into money and now they have money in their name and it's too much money. What do? How could you get that money out and still use it for their benefit? So New York State allows you to create a certain type of special needs trust that basically gives similar flexible rules where this money could be used for their benefit to pay for all sorts of things. But the caveat with this type of trust is that any unused funds goes to pay back Medicaid after the beneficiary's passing. So meaning you could create a special needs trust where the money never touches your child's name and always bypass your child. And in your will, you could say, I'm leaving money just to the trust and never say your child's name. That's going to be the best type of special needs trust because nobody has to pay back Medicaid at the end of the day. But if the money's already in your child's name, you still create a trust, but just know about that Medicaid payback provision. I hope everyone is following so far and that I'm not talking too fast. But let's talk about, and I think we've already been saying it, but just kind of to hone in the point here, the consequences to not having a special needs trust. So without this type of trust created, if your child inherits money or assets directly, it could disqualify them immediately from Medicaid and Social Security. This will leave them without vital services and assistance. This could significantly impact their health and well-being. So a special needs trust is an important tool to know about and ensures that your child could still receive these benefits while also benefiting from any inheritance that you leave them. Okay. I don't know if I said this before, but when creating a trust, it's also important to think about, you know what? I'm sorry, scratch that. I'm going to come back to that point soon as to not confuse everyone. Let's talk about the next type of trust, Medicaid Asset Protection Trust. So this is actually not a trust for your child. This is a trust for you. This is something that comes up all the time. We're not going to spend a lot of time on it, but I want you to know what it is. This is basically, it's often used when somebody owns a home and they want to keep it protected for Medicaid eligibility, later in life, in case they're going to need Medicaid to help pay for healthcare services. So people create this type of trust earlier on. They put their house in it, and they make sure that they could get around Medicaid's 5-year look-back period. And if you have a child who has special needs, you can account for that in this type of trust as well. So therefore, for the trust, when you're talking about the beneficiaries, you would always make sure that any money that would go to your child who has special needs would never go directly to them, but would go to their trust. You can actually refer to their special needs trust in your Medicaid Asset Protection Trust. The last type of trust we're going to talk about is a trust for minor children. If you have minor children, a trust could be used to hold their portion of their inheritance until they reach a certain age where you feel like they're mature enough to manage it. You could set this age. You could say, I do want to leave money to my child, but I don't want them to be able to touch it themselves until they're 25. You want somebody else to manage it for them. As mentioned, before, with wills, minors cannot inherit directly. So if both parents have now passed away and it's time for you to leave money for your children, if you still have minor children, you don't want that money to go, you don't want the court to get involved with that money and have to put it into a guardianship account. You want to put it into a trust because you have much more flexibility with a trust. You could pick the trustee, you could pick all the rules that go along with the trust and have much more control over it. I said this before, but I'll say it again. Speak to a lawyer to discuss all of this because I think it's hard to pick for yourself that like, I need this type of trust and this type of trust. It's good for you to know about what these trusts are and know where they come into play, but allow someone to help you organize that so that you can make sure you're making the right choice. And just to know, trusts could be set up and funded right now, or you could kind of set them up to be funded after your passing and kind of include language for that in your will. There's benefits for both, and there's reasons for both. Speak it out with a lawyer to find what the best approach is for your situation. So let's talk about some other documents. We'll discuss this briefly because I can't imagine discussing estate planning without discussing these two documents. Many people may have heard of them. Everybody should sign them. One is called a healthcare proxy, and one is called a power of attorney. A healthcare proxy is where you designate somebody to make medical decisions for you if you are unable to do so, if you become incapacitated. It's an important document to have in place because you never know what's going to happen. And all you need to do is just make sure you have your document set, and you could save a lot of hardship for the future. Power of attorney. This is where you appoint someone to manage your financial and legal matters if you need help doing so. Okay? Both these documents together are great documents to have because if you don't have these in place, and God forbid you become incapacitated one day, if somebody develops dementia, Alzheimer's, or another reason where they're really just no longer able to make their own decisions, you may have to go through a costly guardianship process if you become incapacitated. So if you have these documents in place, you won't have to do that. We usually kind of just do it all together at my firm. When you're coming in to sign wills or trusts, we always say, let's get some advance directives. These are very important to have. Okay, the next slide I am talking about very briefly, just because this comes up every week at my firm. People always ask me about ABLE accounts, okay? So we're pivoting back, not just really to your estate planning, but let's talk about your child who has special needs for a moment. So again, ABLE accounts are not formally part of the estate planning process, but I do know a lot about them, and I am able to offer some more information after the seminar if you want to email me or call me about it. But let's just talk about what it is for a second. An ABLE account stands for Achieving a Better Life Experience. It's a tax-advantaged savings account designed for individuals with disabilities. It allows them to save money without affecting their eligibility for government benefits. And you can have both an ABLE account and a special needs trust. The contribution limits are about $18,000 annually. The rules are kind of lax for what this money could be used for. Really, the ABLE account could be for anyone, but I've found that it's very useful for people where their children might have some ability to manage some of their own finances. They just need assistance. And maybe they even make a modest income that they want to put into there. You could set up an able account to kind of have it a link to a debit card, and you can really help your child manage it in that way. But again, not part of estate planning, really. It just comes up all the time. If you want more information or resources, please email me afterwards, and I'd be happy to share more with you. Okay, next we're going to talk about something called the letter of intent. This is a non-legally binding document that provides guidance and care about your child with special needs. The reason why it's important to create this is because when you're thinking about doing a will and a trust, you want to also think about, well, who's going to take care of your child with special needs? What do you want them to know about your child? You want them to make sure you know who their doctor is, any emergency contact they may have, any diagnoses they may have. You might want to keep some important paperwork together, like if you have guardianship, their birth certificate. But a letter of intent really just includes a lot of important information. There's nothing so crazy novel about this kind of document, but it's really important to create it. It often goes overlooked. If you write all this stuff down about your child with special needs, you're going to make it a lot easier for a standby guardian or for anybody that might be managing your estate after you pass. You're going to make it easier for them to know how to help and take care of your child who has special needs. So you keep this document alongside all of your other important documents. Now, I want to bring this all home for you guys because we really spoke about a lot of things today. And I understand that for some of you, even if you've heard of a lot of these concepts, it could kind of be heavy to think about them and understand where they all come to play. And it could kind of make your brain go to mush to think about that. So just put everything on the back burner for a second. Let's talk about you. Let's talk about your families and what you could do practically today to help make sure that you're really planning. You're really planning for your family, for your life, and making sure that you're leaving your family in good hands. So if I had to leave you with anything, it would be this. Everybody should have a will. Everybody should have a will. Especially if you have children, especially if you may have a child who has special needs, especially if you may have children from different marriages, especially if you may have complicated family dynamics. But really, everybody should have a will. And that's a really important thing to remember. So to review a little bit what a will could do for you, it could designate guardians for your minor children. It will decide how your assets are divided so that they're split up the exact way that you want it. Account for your child who has special needs. Account for your minor child. Think about the way that you want your assets to look if only one spouse passes away. Think of the way you want your assets to look if both parents pass away. Create a will, make instructions. Don't leave it up for anybody to guess, and definitely don't leave it up to the state to decide for you. Consider a trust. Trust can address a variety of needs, like we've discussed. Consult a lawyer to determine if setting up a trust makes sense for your situation. I don't know if I mentioned this before, but sometimes people call me and they say, I have a child with special needs. I'm setting up a special needs trust. Here's this money, put it in the trust for me. And after speaking with them, I think you're on the right track that you're thinking about a special needs trust. But I'm not really sure why you want to set one up to exist right now, or maybe I'm not sure why you want to fund it right now. Because during your lifetime, you want to keep your money as free as possible. Maybe if you say okay, I'm putting $50,000 in this special needs trust, you now just put that money in the trust. Let's say you need the $50,000. Let's say you need to spend it on your other child or something else important for your family. So during your lifetime, while there may be reasons why you want to set up a trust and even fund it, you should really think about how much money you're putting into it, because you want to keep your money as free as possible during your lifetime. Okay. Advanced directives, don't have much to say. Sign them. Do a healthcare proxy. Do a power of attorney. Don't even think about that. It's just sign those documents. They're very important. At our firm, we do a whole bunch of things here. While I do the special needs planning division, we also do a lot of elder law here. And we see what happens when people don't have their advance directives in place, and it just doesn't make sense. Just sign them now, sign them early, sign them when you're doing the rest of your estate planning. It's good to do. And now I wanted to touch upon guardianship for someone who has special needs. I give full seminars on this as well, and it's something that I handle every day at my law firm. I'll talk about it briefly. When an individual turns 18 years old, any individual turns 18 years old, the law now presumes that they are able and capable of making all of their own decisions. However, for some, that doesn't work. For some people, they're not able to make all of their own decisions, and they really need their parent to keep making it for them due to an intellectual or developmental disability. If you want to learn more about this and whether it's right for your family, contact me afterwards. I don't want to spend so much time on it during this seminar. I just want to go with a couple of takeaways. So first, my name is Malkie Scher. I work at the Moskowitz Legal Group. Thank you for letting me present this seminar to you. I want to make sure that everybody thinks about making an estate plan to address your family's needs. And if you want to talk to me, you want to talk to my firm, this is my contact information. I do special needs planning and guardianship. The rest of my firm does elder law, and trusts and estates as well. And also, I can also provide referrals for you for financial advisors who specialize in special needs planning, helping to maximize your assets. Let's say you want to do life insurance and investment to ensure your family's financial future is secure. So if you want any referrals for that, please contact me afterwards.